Welcome to episode 5 of Startup Dudes. I'm Todd.
I'm Bill.
He's my dad. We're going to talk today a little bit about the differences between copyrights and trademarks, and I think you have some questions prepared, yes?
Yes. I thought it would be a good idea if we contrasted the two of them a little bit, trademark, copyright, so you get a much more comfortable understanding of how they work in helping with starting up any project you might have. So I guess we should start off, Todd, by if you could explain what some of the differences are between the two.
It is interesting, isn't it? Because sometimes you watch popular media and they'll reverse these things. People talk about getting a name copyrighted and this type of thing. It's just not right at all. There's an easy way to keep them straight for the rest of your life. The way, let me tell you what they are. So trademarks have to do with protecting brand identity. And so usually that's done in the form of a logo or a text, like the name of a company, something like that.
We should probably add a few examples as we go along.
For sure. A great example of a symbol or a symbol which does not have the name attached to it that you would all recognize as the company name would be the Nike swoosh. You don't need to spend a lot of time thinking about who is that when you see that swoosh, right? So you can trademark that logo or that icon. And then Nike also has a trademark to protect the name of their company, Nike. So that's trademark, and we'll come back to why you care. Copyright is protecting creative expression, and the list of things that you can protect under copyright is much longer. Songs, you have original compositions that we've trademarked or we've copywritten. You can protect music, scripts, films, designs, like you create this incredible design. Let's say it's a desk or a piece of furniture. So it's creative expression. So the C in copyright always reminds me that that has to do with creative expression. And then the word trade and trademark reminds me that it's all about commerce, which is what brand identity, that's connected to brand identity.
Okay, good. Which one is better?
Neither is better than the other, right? It depends.
I knew you were saying
I know. That was sort of a setup. So if you have a great name and you want to protect it from, number one, from someone else using it, or number two, from the marketplace being confused about what you do, you would want to take the time to protect that by going through the registration process, which is the several steps. We touched upon it a little bit in episode 3. You would want to get it registered. Copyright would be something that would be great if you wanted to protect a piece of your material. I have clients that say sometimes, well, I've got thousands of photographs. How do I know which ones I should copyright? And what do you think I told them?
None of them.
No. I said, let's pick the ones that you think have the most commercial value, the ones that you think you can license, the ones you think you can maybe sell at some point in the future, the ones that you can make originals from or copies from the original. I would say do those because it can get a little bit expensive and time consuming to do it. Copyright application right now is about $45 per image, and you literally take this piece of material, once you've identified what it is it a literary work, is it visual work, and then you would upload an image of that material into the copyright database. So it's literally the Library of Congress that you're sending this stuff to. And it's essentially providing documentation that you are the author, that you uploaded it at this point in time, that you made it available to the general public, you published it, and then in exchange for all that, if you can demonstrate that, they'll protect you for up to 70 years after you have died from others taking it as their own or using it without your permission. It's pretty powerful. And if you find that someone's infringing on your material, you can sue them in federal court, and there are what's known as statutory damages. So the court says you get this money because it happened. You don't have to even prove damages in that case. So it depends on the situation. Depends on what you. I mean, as a musician, you are going to be more interested in copyrights for that stuff. But we've created some cool logos and things and brands that we would want to protect under trademark.
Well, since you mentioned my songs, BillUglowLoveSongs.com. If you want to look at or listen to it, it's free. BillUglowLoveSongs.com. Okay, so let's go to the legal symbols. TM, and then the R with the circle. They're both related, right?
Yes.
TM and R with the circle. We've all seen them, you know, in text and on products and so
Signs,
forth.
even on signs.
So what do they both mean, and what's the difference between the two?
So TM stands for trademark, and essentially you're allowed to make the TM notation on something when you've gotten to the point where you're calling it your own. So you can pretty much do that on day one, and it usually goes on the top right hand corner next to the logo or the name. If it says circle R, that's when you have to be sure and be careful that you've actually gotten it registered. That is a short way of saying that that mark next to it has been registered with the trademark office at the federal level. And that takes time. That could take, right now it's taken about 1.5 years to get a registration done from the point that you submit an application to it having gone through the process, assuming there's no, people objecting to it. And then there's the Circle C, right, which I know you're very familiar with because you worked with that a lot with in merchandising, right?
Yeah.
And that simply says that you've got copyright. You're claiming copyright protection on it, and you can do that again right away. And then at some point, you're going to probably get it registered through copyright, and then at that point, you've got the certificate.
I still remember what we said, what Disney said. It was this was before we got everything back from the registration where we could use an R with a circle. We started off with TM and Circle C. Remember that was the image. TM and Circle C.
TM/C.
Yeah.
Disney.
Walt Disney Productions at that time.
Yeah.
Now it's called Walt Disney Company. Walt Disney Productions, all rights reserved.
Yeah.
That's what we were, as I remember.
Yeah, because at one point, the all rights reserved notation was something that most legal advisors recommended you put. You don't need to put that anymore. So in fact, Disney now, all they say is see Disney. If you look at 99% of their products out there, it just says see Disney. Yeah, not even Disney, Walt Disney, not even Disney Productions, just see Disney.
Okay, and then, okay, so we can use TM when we decide that it's our market and we want to declare to the public that we consider this a trademark, whether we register it or not. What goes into the decision-making process relative to actually going through the process of getting it registered?
Yeah.
Money-wise, I guess, and time-wise, and rejection-wise, and all that.
So from a startup point of view, whenever you get, let's not forget, these are pieces of intellectual property. They're assets on the books, just like inventory or buildings or anything else. So when you are starting a company and you can get these things registered, you're building asset value. What they're worth is a different question, but they are assets, right? So one reason why you would do it is if you are trying to build value in your company, it goes on the books as an asset. Number two, if you're going to be going to the market publicly, whether it be online or in brick and mortar, it just establishes a lot of credibility that you have taken the time to try to protect your brands. Not to mention, somebody could see how successful you are and steal your idea. And at least if you've taken the time to register either your trademark or your copyright, you've got some legal protections that you can fall back on. And whether or not you pursue, that's maybe a different episode, because as you point out, it can be very expensive and time consuming. But to get a registered trademark all in with legal fees and everything, you can get done for under $1,000, which may not be a huge investment for some companies. Copyright you can get done for all in for $250 to $300.
Very interesting. So Todd, in summary, kind of summarize if you think there's any single takeaway with respect to trademark, copyright, and intellectual property protection in general. Is there anything we should take away if there's any single thought?
I mean, probably the most common question I'm asked is, should I do it or shouldn't I do it? And we work with almost all of our clients are startups, so they don't have tons of money. And so they're trying to figure out how to spend those precious resources. I think that if you're going to make a real serious go at it, it makes sense to register your trademark, especially if it's your main brand, and to protect those copyrightable items that you think represent the most value.
I agree with you.
So,
Well, that winds up this episode. Thank you very much for watching. We have more to come.
appreciate you watching, and I'll put some notes down in the description